respondent, full stop. As a last chance to the respondent to appear and contest the applications, the same is adjourned for the day. For the day means we'll take up on Monday first. Give all your names. Give your name also. Yes. No.
For the appellant, my lord. My lord, Mr. Chakraborty is appearing for the appellant.
Which Mr. Chakraborty?
Sukanta Chakraborty.
Oh, since the matter is released on the personal grounds of one of us within bracket Bhattacharya J, with liberty to the parties to mention to seek assignment before a different bench. Sorry.
Season's greetings.
Same to you. Same to you. All of you.
I am for the appellant.
Yes.
The suit for partition declaration and
Appearing for the first time?
first time.
No caveat.
No caveat. This is
Suit
an
for
application
partition?
for leave to appeal.
Some of the heirs have been missed
yes,
out.
Yes. After paragraph 4. The preliminary degree was drawn up 23rd February 2000. 2008. That is a mistake.
No, the heirs, the death occurred before the decree. You say.
Yes, but
Before the impugned decree.
Final degree. After preliminary degree, before final degree.
You are challenging the final degree.
Final degree.
So before the final degree, the person died.
Right.
Given a
And
4.
no substitution application has been filed.
4 and 5 both died.
4 and 5 both died.
So the heirs you are wanting to.
This is a page 5 schedule.
Achha. You have not served copy. That is the difficulty.
No. Soft copy. If your lordship direct me,
will direct you to serve.
Yes.
Very well. The appellant shall serve copies of the application on the respondents, indicating that the matter shall be listed under the same heading on November 25, 2024, when the appellant shall file an affidavit of service.
Grateful.
Number 67.
What is the defect?
Delay, I suppose the deficit court fee has been paid, your lordship.
Achha. Let us just check up for the 2 defects.
3% delay.
Your lordship.
3% as we.
It days delay. You have filed an application for condemnation.
Your lordship, this is a change brief, your lordship. I suppose that was filed by the erstwhile advocate on record.
But you have to go through the records before.
I understand, your lordship, the first day of the. I tender my apology for this.
No, not that, but you have to just take up whether the one is stay, the other is.
No, defect the attached deficit court fee দিয়ে দিয়েছে ওটা।
No, I suppose there is no. We can't find any application for condemnation.
Your lordship, may I come back?
Come back.
Perhaps there.
There is.
Delay.
Oh yes, there is
Delay.
a condemnation application.
I tender my apology.
So we'll allow the condemnation application 8 days delay. And what else? Stay.
Your Lordship, the stay on the stay point, Your Lordship, I have also prepared a supplementary affidavit, just 2 documents. The sum and substance of matter.
Copy has been given to them?
No,
No.
no, I will serve here and now.
Very well. Condonation we are allowing right now, and the stay application, you serve copies of the supplementary affidavit, come back.
Stay served.
Stay served.
No, no,
Stay served. The
supplementary
supplementary
affidavit.
Supplementary affidavit.
Your Lordship,
We'll take the supplementary affidavit on record and serve copies on them.
Lord, in that case, Lord, kindly passes that, Lord, direction for filing affidavit in opposition, because eviction decree, I will be praying for occupation charge.
Your Lordship, the only,
Definitely.
Your Lordship, the only difficulty is now, this is a landlord-tenant dispute. Similar same premises, another suit was filed. That suit was decreed. Now they are proceeding the execution in that suit. In this matter, same premises, same parties, they have filed another and they have obtained the decree. I am paying stay for on this decree on which they are also proceeding on the execution. In the lower court, the matter is still pending. With regard to that,
We will keep the question of occupation charge open, Mr. Bhattacharya, but there shall be a limited stay. Otherwise, if you proceed with the execution, nothing. Execution case has been levied.
Yes, levied and they are proceeding. Officer has been engaged, and Your Lordship, on the previous ejectment suit, the decree was set aside and cross-examination is going on.
Very well.
Milord, what happened, Milord? There are 2 suits, Milord, 2 premises. Once, Milord, we got a decree for eviction. They came up in first appeal. Now, in the first appeal, Milord, the Honorable Division Bench was pleased to set aside that judgment on the ground that they were not given an opportunity to cross-examine on the principles of violation of natural justice.
Yeah, they were given in this.
Then it was remanded. Now again, Milord, we have got a Milord on contest. Milord, again, Milord, a decree for eviction has been passed.
That is the present appeal.
No. That is the other suit.
That is the other suit. And in this suit, it was decreed and we have come up in a first appeal.
This is for the first time.
This is for the first time. 2 suits on the
in this suit also, then same defect must be visiting this.
Yes.
So because if those are hard analogously, then on the same ground, this should be allowed.
Your Lordship,
If you concede, Mr. Bhattacharya, we can do it.
I have a similar set of grievance, but I leave it to Mr.
But they have a prima facie case then. Can 1 of 2024 is an application for condonation of the delay in filing the appeal, push up, in view of the minuscule delay and the sufficient grounds having been made out for the same, comma, can 1 of 2024 is allowed, comma, thereby condoning the delay in preferring the first appeal bearing FAT number 172 of 2024. There will be no arise to cost. Pushed up. Next para. Can 2 and 3 are similar?
Can 2 is my stay.
What is can 3 then? Let us see. Can 3 also similar prayer? Check up probably will not press. I don't know.
I will not press then. I will just check up.
Check up later. Can 2 and 3 are now taken? Can 2 of 2024 and can 3 of 2024 are now taken up for hearing together? Full stop. But you have prepared this supplementary in connection with can 1. No, don't file it today then. Next para, learned counsel for the appellant seeks leave to file a supplementary affidavit in connection with the said applications, whose have accordingly such leave is granted and the supplementary affidavit shall be filed on the next returnable date with advance copies of the same to the learned advocate on record for the respondent within a week from date. Push up next para. The respondents shall file a composite affidavits in opposition against the 2 applications and the supplementary affidavit within 3 weeks from date. First of reply, if any, shall be filed within a week thereafter. The applications shall be listed for hearing together next on in the monthly list of December 2024. First of there shall be stay of operation of the impugned eviction decree and stroke or the connected execution proceedings till December 15, 2024 or until further order, whichever is early.
Number 68.
May it please your lordship, my lord.
Yes, please.
This is an application, my lord, for appropriate order. The appeal has been admitted. The respondent wife is the applicant herein, my lord. The divorce my lord, degree as prayed for by the husband, my lord, that was not granted. The suit was dismissed, my lord. Against that, my lord, assailing that, the husband has filed an appeal. Now, since June 2024, my lord, the husband has stopped payment of, my lord, the maintenance, my lord. So since
You are the husband.
I am the wife, my lord, the applicant wife.
Oh, acha, acha.
My lord, I was praying for, my lord,
So
continuation
I'm
of
sorry, the divorce decree, the suit was dismissed, they have preferred this appeal. So this is for maintenance.
maintenance, my lord. The
So why do you say appropriate order?
No, it's an application for appropriate order, my lord. I have prayed, my lord, for continuation of payment of the amount as was being paid by the husband.
Trial court.
My lord,
1 lakh was being paid in the trial court.
My lord.
What does he do?
my lord, he is very highly placed, my lord. My lord, if I go back to the background, the wife had some mental problems. Now, my lord, the conduct as per the degree, my lord, of the husband aggravated that. But the husband,
So what does he
used-
do as a by way of
my lord,
occupation?
my lord, he is in service, my lord, and he had himself volunteered also, my lord, payment of money during the pendency of the divorce
1
proceedings.
lakh.
No, not 1 lakh, my lord. Subsequently,
So
that
1 lakh was
enhanced.
granted.
Yes, 1 lakh was granted subsequently by virtue of
He's assisting you or other
lord.
side.
no assisting me. in
But
the
then you
case.
have to serve a copy.
Yes, Mr. Shu. No, we have served, my lord. The affidavit of service is here, my lord.
But there is no affidavit of assets annexed with this.
No, with
That's
this,
a
my lord, there
requirement
is,
now.
I am praying for, my lord, continuation of payment of
No,
this
no.
particular amount only.
This is an application. You have to
Very
file
well, I'll do
current
that, my lord.
affidavit of asset.
Very
Mr.
well, my lord. One may kindly direct me, my lord, pass it
I'll
on to my lord. I'll do
We'll
that.
do it. The affidavit of service filed today be kept on record. Full-stop, despite service, none appears for the respondent, stroke husband. Full-stop. Although the application has been couched in the form of 1 ONE1 for appropriate orders, seeking continuation of the payment of maintenance by the husband as paid by him during pendency of the suit, comma, the crux of the prayer is also one for maintenance, and as such, comma, the uh, applicant wife is required to file her current affidavit of assets as well.
Right.
Push up next para. Accordingly, the applicant is directed to file. You are the respondent in the appeal.
My lord, yes.
The respondent stroke petitioner is directed to file her affidavit of asset in support of the application for appropriate order within a fortnight from date and serve an advance copy of the same on the respondent,
Lord,
on the
may I-
appellant husband,
May I serve it upon the advocate on record for the
comma, directly and stroke or through his learned advocate in this court, and file an affidavit of service to that effect on the next returnable date. Full stop. The respondent husband shall file an affidavit in opposition, a composite affidavit in opposition to the application as well as the affidavit of asset within a fortnight thereafter. Full stop. Reply, if any, shall be filed by the respondent stroke petitioner stroke wife within a week thereafter. The repeat হয়ে গেল. Next para, the matter shall next be listed for hearing on December 9, 2024. We are not granting any interim order in the meantime before hearing them, but let us hear them.
grateful to your lordship.
Defect, what is the defect? Thank you.
Defect,
Could have checked up. Thank you. There's a defect.
Appeal আগের দিন defect remove করে in the appeal, my lord, there was a defect, my lord. On
What
the
is the
last
defect?
occasion,
In the appeal itself, there was a defect.
yes, that was possibly Mr. Dotto appeared, and that defect was possibly cured also, my lord.
What is the defect?
Certified
Uh,
copy of order. Decree has
হয়েছিল
not-
বলো তো
মেমোটা
defect টা?
কোথায়? আদিত্য, অরিজিনাল মেমোটা কোথায়?
না না একটা I indicated that, my lord, on the last occasion on
It has been
19th of
filed
June.
subsequently.
I need to check that up, my lord. Because
একটা লাইন অ্যাড করে দিন তাহলে, the appellant shall, comma, if not already filed, comma, furnish a copy, a certified copy of the impugned decree in the meantime.
I had taken that point categorically, my lord, on 19th of July, but
No, but let them do it.
yes, grateful to your lordship. Post vacation, my lord, I am seeing one.
অরিজিনাল ছিল দেখি। তাহলে ওটাতে দুটো কি আছে? ঠিক আছে, চল, পরেরটা। Yes.
Post vacation, I am noticing a significant change, my lord.
What?
My lord's hairs have grayed a little bit.
Yes, great. Not only great, the few which are there, thanks to you people.
But I do not know who I will thank then.
Yes, next.
শুনতে হবে না 69 69 69 ডিরেক্ট আছে আমি বলে দিচ্ছি আসলে সেকশন 5 এর করা তোমার 16 69 মানে there is a
Yes, Mr. Rai.
there is a defect manner for 4 days from date of notifying the stamp and deposit of stamp. That period should be excluded. My junior has it is my fault, my lord. That period has been taken into account and 4 days delay has been
They
recorded.
filed as section 5.
I have to file, my lord. That was escape of a notice.
Since the appeal is time barred by a few days, comma, learned counsel for the appellant seeks some time to take out an appropriate application for condonation of such delay, full-stop. Such leave is granted, full-stop, liberty to the appellant to mention the application as and when filed for inclusion in the list. For the time being, it is listed by actually. The matter shall go out of the list for the time being with such liberty.
Careful.
এই আদিত্য এটা এফএটি এইটা যেটা ছিল না 3-4 মিটার আগে উড়ে গেছিল যেটা সেটাতে ঢুকে যাবে বলে দিয়ে বিজলিকে দেখে করে দিই 4-5 মিটার আগে উড়ে গেছিল
But I'm for the appellant.
Yes.
But before going into the merit of the case, what happened? Challenges the partition suit decree. Number challenging the said decree, preliminary decree, 2 appeal has been filed before this honorable court as well as before the district, before the landed district judge. But the appeal before the landed district judge will not be maintainable because of the valuation. But I am required to be withdraw that.
This is the suit for partition one. And in suit
withdraw that and come back. When can you come back?
Yes, my lord. Can you give me 15 days time?
We'll keep it in the next monthly list then.
Next month.
Learned counsel for the appellant rightly fairly points out that against the same preliminary decree, comma, 2 appeals have been preferred, hyphen, one before this court and the other before the district court. First of, however, comma, it is submitted that the district court appeal is not maintainable in view of the valuation. First of, in order to enable the appellant to not press the appeal pending before the district court, in the meantime, comma, the matter is adjourned and shall next be listed under the same heading in the next monthly list, when the learned advocate for the appellant shall furnish some document to indicate that the appeal before the district court has been disposed of as not pressed. Come back on that date and
finally record my appeal. I'm appearing for the response.
give your name, it will be automatically
But I've
recorded.
served notice before. I've served notice. Like a judicial service may be also kept with the record.
আর তাহলে একটা লাইন অ্যাড করে দেবেন যে এফিডেভিট অফ সার্ভিস ফাইল টু বি কেপ্ট অন রেকর্ড
Number 71.
প্লিজ গিভ ইওর নেম
I'm for the appellant.
হোয়াট ইজ দ্য ম্যাটার
The matrimonial suit, my lord, under section 9.
অর্ডার 41 rule 27
Yes, my lord, there are 2 applications. My lord, order 41 rule 27, which I cannot place, my lord, right now. It has to be heard with the appeal. There is an application for stay. My lord, stay, my lord, because the husband is the appellant before your lordship in a application initiated under section 9 of the Hindu Marriage Act for the restitution of conjugal rights. There, my lord, the learned judge has come to an opinion that if your lordship takes up the memorandum of appeal,
I'm sorry, I missed out. Yes, I am trying to find out the other application.
my lord, the application
Can one is for
order 41, can 2 is for stay.
can 2টা কোথায় ইয়ে যে অ্যাপ্লিকেশন লিস্টে আছে সেটা তো বার করে দিতে হবে আপনার কাছে ক্যান 2 আছে ক্যান 2 লিস্টে রয়েছে মানে নিশ্চয়ই থাকবে দেখো ভালো লিস্টে ছাপা রয়েছে তো ঠিক আছে
Should not come.
no what is can 2 for
Can 2 is for stay. My lord, what happened? My lord, section 9 application.
no, Mr. Mukherjee, let that come. We'll come back next week. Although can 1 of 2024 is appearing.
My lord, may I serve and come back also in the meantime? Because order 41 rule 27 has to be heard, my lord, along with the appeal.
No,
My
order.
application for stay is based on a separate suit initiated by the wife for divorce, seeking for divorce. If this section 9 application, which has been turned down,
Yes.
this will be an evidence by virtue of which that will be decreed, my lord. I prayed for stay of that, my lord's divorce suit.
Although can 2 of 2024 is appearing in the list, comma, the application is not physically found in the records. Full stop. Let the said application be tagged with the main file and be placed in the list for hearing along with can 1 of 2024 on November 11, 2024. Where can we find that application? It was filed for which court?
My lord,
Just
can,
pick up that.
yes, my lord, can one
Please
file
indicate that
the
in a
same court, courtroom number 4, before courtroom number.
code number 4. So please on a slip of paper ask your learned
Yes,
junior
yes.
to indicate so that we can
Yes,
requisition
my lord,
properly.
yes.
Requisition correct.
Great. লিখে দাও। Yes, sir.
Give the item number and the code number.
Yes.
Number 72.
Appellant, what is the defect? Out of time. These are condemnation app? Yes. Have you served on the other side? Serve and come back. The appellant shall serve copies of the application on the respondents indicating that the matter shall be listed next in the monthly list of December 2024 and file an affidavit of service on the next date. Thank you.
Your Lordship, I am appearing for the appellant. My lord, defect has been cured as told by the learned advocate on record. My lord, I have served both the copies of the section 5 and the, my lord, stay application to my learned friend's advocate on record as because there was caveat.
I am appearing on
You have not got a copy?
I have got copy of the stay application and the section 5.
Yes.
Memo he has not served.
No, there's a report of 2nd of August 2024 saying that still certain defects persist. Section 5 we have filed, so that
Yes,
goes.
section
Proper
5
court
file,
fee
court fees has been paid within time, my lord.
and preamble to the memo of appeal is bereft
Yes,
of the
that
name
has
of.
been corrected.
So then all have been correct.
Yes.
Yes,
My lord,
Mr. Yes.
41 days delay is there, according to me, though the stamp.
What is the appeal about? I mean, against what decree?
Yes, my lord, I am the plaintiff in the suit. My husband was the plaintiff. I got substituted. Suit was filed for a declaration that, my lord, I got the right title interest of the suit property by way of adverse possession and adverse possession and not to be evicted due process of law. They filed a written statement in the nature of counterclaim, and their case, the defendant's particular case was that, my lord, they gave licensing from 2013 onwards. Not a single scrap of paper was placed for licensing. My lord, it is an admitted position that so far the exhibits are concerned before the learned trial court, documents pertains to show that my husband, who was the original plaintiff, was in possession since 1963. So my respectful submission.
You have to prove so many things in adverse possession. Hostile possession, continuous
That's
possession,
true, but my lord,
commencement date,
so
exact.
far counterclaim is concerned, my lord, my respectful submission before your lordship would be.
If you fail in a suit, automatically counterclaim follows.
Yes, but on the basis of, my lord, misrepresented facts or incorrect facts.
You
whether
are
a
the
counter-
plaintiff. You have to show, even if you are the defendant, you have to show your adverse possession.
My lord,
Adverse possession should have you seen any adverse possession should succeed?
my lord, your lordship has vast experience.
You have
my lord.
not seen, I have not seen, my senior had not seen.
My lord,
Before that, I don't know, might have been.
my lord,
Before that, adverse possession in any event was only a shield. Now it is also a sword in certain contexts, but I have never seen or heard.
yes,
Yeah. So
but
presumption is you don't have any case.
But
What is the delay?
my lord, only
Have some satisfaction regarding the delay.
yes, my lord, delay I have indicated.
What is the delay?
My lord,
Period
delay,
of-
my lord, I got the certified copy and thereafter.
What is the period of delay?
41 days.
That I'll condone.
My lord,
Lordship, I leave it to your lordship.
What is the can number of the delay?
my lord, can 2.
Can 2 of 2024 is taken up for hearing. Full stop. Upon hearing learned counsel for the parties, we are satisfied that sufficient reasons have. Can 1.
Can 1.
তাই তো হওয়া উচিত তোর ওইটা state
Thank you.
করতে-
Bhagis bolun. Can 1 হবে?
Can 1.
that sufficient explanation has been given for the delay in preferring the appeal. Full stop. Accordingly, can 1 of 2024, thank you. Can 1 of 2024 is allowed without an order as to cost, comma, thereby condoning the delay in preferring the first appeal bearing FAT 198 of 2024.
My lord.
Stay we won't grant.
My lord, 25th is the date for my lord belly possession. My lord, kindly protect me for some time. My lord, I am the unfortunate wife, my lord. I step
You are
into
not the
shoes-
unfortunate wife of the respondent. He is not the unfortunate husband of you.
My lord, kindly, my
The
lord,
unfortunate person who owns the land.
my lord,
Lordship, kindly expedite the appeal, Lordship.
my lord, kindly, my lord,
Lordship.
No, no, we'll
Some
refuse
protection.
stay.
my
We'll
lord.
refuse stay.
But regarding
Show us your best point. Listen, show us your best point.
My lord, so far, my lord,
You have to prove prima facie case. If it's an adverse person suit, you have to prove.
memo-টা দাও।
Not as a matter of course. Did you enjoy any injunction in this suit? I don't think so.
Yes, yes, yes. Till disposal.
Oh,
Yes.
what is that order? You should have annexed that order.
My lord, that order has not been annexed.
Anyway, we have to satisfy us.
My lord, so far, my lord, if your lordship kindly takes the judgment, my lord, subject to correction from your lordship, my lord, memo, I am placing the memo, my lord.
Yes, show us which page of the judgment.
copy of the memo may be given, Lordship.
Yes, but you must have the judgment and degree.
I have
Yes.
got the judgment.
Yes, I have given.
He is referring to the judgment only. Grounds we are not interested. Let us be satisfied on the judgment itself.
My lord, kindly, my lord, come to page, my lord, 9 onwards, my lord.
Yes.
Page 9, my lord. I am trying to satisfy your lordship, my lord.
Show us what proof did you give of adverse person?
My lord, my
What was the commencement date of your adverse person?
1963.
Date, time, adverse person.
My lord,
Year
time
will
has
not do.
been given, my lord.
Then,
My lord,
no.
1963, my lord, it has been stated, my lord.
Year will not do. Adverse person, you have to say in this manner, I came in possession at this time, this date,
My
particular
lord,
date.
the evidence, your lordship kindly appreciate one thing.
1963.
My lord, the evidence has been cited by the wife. At that material point of time, the husband, who was the original, my lord, in adverse possession, was expired. And she is the second wife after the divorce wife.
How
So,
does that make a difference?
my lord, she is not acquainted.
She is claiming she has stepped into the shoes of her husband. So, husband,
Absolutely.
if the husband was not in adverse person, presumption is, Mr. Mitra, that it will be
My lord.
licensed. Even
lord.
if they could not, license need not be proved.
Yes.
If it is seen that you are not in adverse person, either you are a trespasser or you are a licensee, they made it a better case for you saying that you are a licensee. Otherwise, you
from
are a trespasser.
2013 onwards, your lordship kindly appreciate.
2000, why 2000? Even if you are a trespasser for a century, you remain a trespasser for a century.
Yes. My
Or
lord,
a licensee for that matter.
yes. Now, my lord, your lordship kindly.
The entry point had to be trespasser. Entry point, yes, you could have shown adverse person.
My lord.
But no, 1963 itself takes away your case. Because page 9 says this statement is contrary. You have said in the plaint you were in possession since 1963.
My lord. And in
1963
support of my contention, my lord, the driving license
your
and
possession
other,
is not disputed. That is
yes,
the
I
difficulty.
understand. I understand.
Your
But
entry point is disputed.
Yes.
It had to be hostile and within their knowledge throughout.
Yes.
The hostility had to be within their knowledge.
Yes, yes, yes. Right from the very beginning.
Yes, you know,
Yeah,
all of you, all of us know what are the
My
ingredients of
lord,
that.
my lord, kindly, my lord, give me some protection, my lord. Prima facie, kindly fix a date for hearing, my lord. Otherwise, my lord,
How can I fix? How can we fix a date for hearing?
my lord, a stay has been filed, my lord. I have served. If my learned
No
friend,
stay. Stay will be refused. We will refuse. Reject the stay application.
my lord,
No prima facie case.
my lord, then kindly fix a date for hearing, my lord. I will
How can you fix
try
the date?
to-
How soon can you prepare paper books?
then expedite the appeal, your lord, if your lordship.
We can do that. We will
My
do
lord.
that.
My lord.
The Vakalatnama in the caveat may be treated as Vakalatnama in the
Very well. Thank you. Thank you. Fair enough, Mr. Rai.
Yeah.
What is the can 2 is the stay application?
Yes.
Can 2 of 2024 is now taken up for hearing. Full stop. Next para. Even after a careful perusal of the impugned judgment, comma, we are unable to satisfy ourselves that a prima facie case of adverse possession, a prima facie case of title by adverse possession has been made out by the defendant stroke, by the plaintiff stroke appellant. Full stop. In fact, comma, it transpires from the discussions in the impugned judgment that the plaint case was merely that possession of the plaintiff's possession of the appellant's predecessor in interest stroke husband was since 1963, comma, as such indicating that the exact date and time and manner of entry at the juncture of commencement of purported adverse person has not been pleaded, comma, let alone be proved by the appellant. Push up next para, be that as it may, comma, in view of no prima facie case having been made out in the appeal, comma, we are unable to grant any relief of stay. Push up accordingly, can 2 of 2024 is dismissed on contest without, however, any order as to cost. Push up on the prayer of the appellant, comma, the hearing of the appeal is expedited. Push up, the appellant shall put in the record shall be called for by special messenger at the cost of the appellant, which shall be put in within a week from date. Push up, the appellant shall also comply with further formalities within a week. Push up, in view of appearance of the respondents through all the respondents you are appearing.
Lordship, the rest of the respondents didn't contest in the lower.
You are respondent number 1.
1 and 2, Lordship.
In view of appearance of respondent numbers 1 and 2 through counsel by way of lodging a caveat, comma, service of notice of appeal on these respondent numbers 1 and 2 is dispensed with. First up, the Vakalatnama filed with the caveat be tagged along with the main file and be treated to be the appearance of the respondent numbers 1 and 2 in the appeal.
Grateful, madam.
First up,
The rest
despite
didn't contest,
service,
Lordship.
they did not.
They did not contest.
Insofar as the other respondents are concerned, comma, since despite service, they did not, despite service of notice, they did not contest the suit, comma, notice on the other respondents is dispensed with. First up, next para, the appellant shall prepare requisite number of paper books within 6 weeks. We are making
Informal, Lordship, that will be
informal paper books within 6 weeks from the date of service of notice of arrival of the lower court records on the advocate for the appellant. Puts up liberty to mention the appeal for hearing upon the records are examined and found to be complete.
My lord, as fell from your lordship, I again checked the plaint. My lord, in the plaint also it is indicated as 1963. No,
Yes, yes, it has been discussed.
What is there? That is there, my lord. I,
How can you improve it?
yes.
Yes.
grateful.
Thank you.
I am for the respondent.
Appellant.
What is the defect?
My lord, defect, my lord, I have removed, my lord. But one defect is, my lord, reported by the stamp reporter, my lord, regarding, my lord, valuation of the appeal, which was, my lord, wrongly calculated. It is a partition suit. My lord, kindly see the list of the schedule of the plaint. There are several property, landed property, along with, my lord, one flat in, my lord, Howrah, which will be, my lord, more than, my lord, 50 lakhs or more, even more than crores. But wrongly, it was mentioned 1,30,000 instead of 2,30,000, which learned advocate omitted during the course of the hearing of order 7 rule, because I had got little opportunity. Moment I filed this suit, my lord, the defendant, after having summoned, they filed one application under order 7 rule 11D, and hearing was held. And on that hearing, my lord, it was held that since the cooperative property was one is cooperative flat and other is, my lord, landed property which located at Hooghly. On that ground, my lord, that since it is a cooperative property, there are no partition. For that reason, order 17, order 7 rule 11D allowed. When I filed appeal here, my lord, stamp reporter, my lord, reported that along with others which are my lord correctable, which I corrected, but my lord, on valuation part, my lord, that it should be appeal should be maintained before the learned district judge, my lord, since the valuation is less than 1,50,000 by dint of amendment of Bengal Assam Agra, my lord.
Yes, yes.
My lord, it is, my lord, in place of, my lord,
1,50,000.
Yes, 1,50,000.
That is the last value.
For that reason, I maintain one can two, praying for amendment of my valuation of the plain.
But by filing
But
this
then this
application,
appeal is not maintainable.
yes, my lord.
Appeal is not,
Cannot cure the filing
My
of the appeal.
no, my lord, appeal is not maintainable in order to,
Your plaint has been rejected.
Yes.
plaint has been
As
rejected.
of today, you are challenging that order 7 rule 11.
Yes,
I mean,
yes,
the rejection of plaint.
yes.
So that as of today, as the plaint stood on the date of his rejection,
Rejection is not on the ground of
whatever ground,
lesser
as
valuation.
on that date, the valuation
That
was 1,30,000.
1,13,050.
So your appeal lies before the district court. There you can, before the district court, in that proper appeal, you can take out an application for amendment of the claim. We'll record that and dismiss the lock, stock, barrel.
My lord,
Section 21 is very clear
my
that
lord, my lord,
not only in the plaint, in the nomenclature, in the paragraph itself, paragraph 17, they have also given the breakup and they have
Miss-
said that 1,30,000.
my lord, this is
By
a
filing this application, this is a ploy. My lord, kindly see the paragraph 17 of their plaint.
no
lord, kindly
question of
see.
ploy because my lord, I am
my lord, I have not.
my lord, my lord, the other
My lord, kindly see
res-
their plaint.
What did
respondent
they say?
Paragraph 17, they have said that for the purpose of court fees as jurisdiction, the suit is valued at rupees 1,10,000 for partition and rupees 10 for injunction, and for accounts rupees 20,000 and rupees 5 for receivers. So the extra exact breakup is there. And
We'll
as such,
hold that the appeal is not maintainable, Mr. We'll hold that the appeal is not maintainable, and we'll just say that this will not prevent you from taking the point which you are now taking before the district judge if you prefer an appeal.
but since my lord, it is a partition suit, admittedly it is valued at more than my lord lakhs.
So
few
how
lakhs.
can it be admitted?
My lord, in view of my lord schedule, my lord provided in the
Can be less than 1,50,000. Not everybody is rich like your client. There may be people having property much less than 1,50,000.
Yes, definitely that. But here, my lord, plaint is with the schedule of the property is with the plaint.
At the outset, comma, it is argued by learned counsel for the plaintiff stroke appellant that the valuation of the plaint was incorrectly made, comma, taking it within the appellate domain of the district court, whereas if proper valuation was attributed in consonance with the properties involved in the partition suit from which the present appeal arises, comma, the appeal would lie before this court. Full stop. Next para. Accordingly, the appellant submits that it intends to amend the plaint. Full stop. Next para. Learned counsel for the respondents opposes such prayer and submits that as per the clear averments in the plaint itself, comma, the valuation was less than rupees 1,50,000, and as such, comma, appeal lay against the impugned deemed decree rejecting the plaint before the concerned district judge and not this court. Full stop. Next para. We are more convinced by the contention of the respondents insofar as, comma, insofar as the test would be what was the valuation of the suit at the juncture when the plaint was rejected. Full stop. We find from the plaint that the plaintiff stroke appellant had made clear averments in the plaint to the effect that the valuation of the suit is to the tune of rupees
30,015.
30,015. 30,015. And as such, comma, an appeal against the decree rejecting the plaint in such a suit has to lie before the concerned district judge as per the Bengal, Agra and Assam Civil Codes Act. First up, next para. Accordingly, FAT 199 of 2024 and the connected applications are dismissed with liberty to the appellant to prefer an appeal before the appropriate court having jurisdiction. First up, it is further made clear that in the event the appellant is otherwise entitled in law to do so, comma, the appellant may make prayers for amendment of the plaint before the appropriate appellate court. Full stop. Needless to say, comma, in such a case, comma, the defendants shall be given ample opportunity to controvert such prayers.
May I take back the certified copy after furnishing my lord Xerox one?
The learned advocate on record for the appellant is granted leave to take back the certified copy of the impugned decree upon furnishing impugned deemed decree upon furnishing appropriate copies thereof.
Deeply obliged.
Thank you.
Your Lordship, in this matter, I'm appearing on.
Yes, you were saying something in the morning. Why?
Your lordship, praying for accommodation for the day.
You said that it should be released or something.
Yes, your lordship, because when we see, my senior saw that the determination is of.
No, we have
2020.
determination for current appeals, first appeals.
Okay, your lordship. Then
Why accommodation? Move the matter.
I do not have the instruction, your lordship. My senior is appearing.
On the prayer of the appellants, the matter is adjourned for the day.
Grateful, your lordship.
I appear for the respondents. Lordship, in this matter, Lordship, learned advocate appearing for the appellant, he is engaged in another court.
Who is he?
Mrs. Devdatta Bosu, and Lordship, she has
Yes, he was
requested.
there in the morning.
She has requested by his chamber junior to praying for seeking for adjournment. Lordship, kindly make it not today, Lordship.
He opposed that vehemently. On the prayer of the appellant.
Prayer in their application, that's for injunction. That very vehemently, but not. She has requested by.
Very well. On the prayer of the appellant, the matter is adjourned for the day. But please give your name. Somebody's name has to be there as the culprit. Right. Application শেষ হয়ে গেলে hearing করবো। Random আসতে হবে।
suit আছে 2016 ঠিক আছে up to 2020
হ্যাঁ অর্ডার ফর 2020 এটা 2016 not আমি জাস্ট স্ট্যান্ডার্ডটা দেখে নিলাম ওনার ঠিক উল্টো অর্ডার করতে
My lord, I appear for the appellant petitioner in this matter.
Yes, please.
My lord, I have come up against.
You're for the other side.
I have come up against the or grant of probate in favor of my younger brother by the Barashat assistant.
No settlement is possible, younger brother.
No, my lord.
Property is too high for
the
that.
Property has addeemed, my lord. It has been given on gift to me, my lord. After the will. After the will, I have come to know from the application in 2002. In 2005, the will was got revoked by ademption by gift by my mother.
But one thing, what is your take on that? I mean, will, if it is properly proved, the will stands. But then you have to file a declaratory suit asserting your right, because even if a probate is granted, that is not declaration of title. Probate automatically that does not give title. There may be a valid will with a probate. The probate court only has to see whether it has been executed properly, and if it is executed, probate can be granted. That is not a good ground for challenge to a probate. You can independently file a declaratory suit seeking your title in the property on the strength of the gift deed. Despite the will, you have title.
Lordship,
probate court cannot look into that.
But since my gift deed was, I have produced the gift deed and it was made exhibit and without objection. Despite that, nothing was.
That can be a suspicious circumstance, you may say.
No, not. I do not.
If it's not a suspicious circumstance in a probate appeal, we would not look into a gift deed. Title cannot be looked into by the probate.
My lord, certain actions.
Suppose the usual example. You know very well the usual example. No. Even if I make a will to my son of the Victoria Memorial and die tomorrow,
certainly
probate will be granted if the execution of the will was proper.
Lordship.
But that does not confer any title on my son.
Lordship.
Victoria Memorial authorities, they may file a declaratory suit if my son claims title.
Lordship, but in several judgments, if your lordship kindly allows me, subject to correction by your lordship,
yes,
that in this case particularly, when there is a registered document, the probate court can look into that.
Then bring those judgments. We can decide the appeal and the application together.
Lordship.
Yes, what do you say? What is the application for? What are you asking?
I'm
stay of the
because if some process is committed by the probate holder, if assent is done or disposal is done, which
can you please bring one or two of those judgments, the best judgments which you have, even for prima facie case? Just satisfy us that you have a prima facie case on the injunction, on this stay. Because that is one of the things which is irking us. Whether probate court can look into the title.
Lordship, Lordship, those are
Any day, any day.
Your
Come
lordship
back
kindly
next
takes up
Monday.
to-
Next
next
Monday.
Monday.
Yes. Please come. You also come prepared on that.
Absolutely.
Since a prima facie doubt has occurred as to whether the appellate court in connection with the probate proceeding can look into the title of the parties, comma, learned counsel for the appellant seeks some time to satisfy the court on such count with certain citations. Full stop. Accordingly, the matter is adjourned for the day and shall be taken up next on November 11, 2024. Thank you. Let it be called on first.
Waiting for that.
Yes.
Item number 78.
But
I beg to appear
the-
for the plaintiff
for the
respondent.
Respondent.
I'm for the appellant, my lord. I could not, my lord, my clerk could not raise the brief. So I not carrying
Next
the brief
Monday.
today. Any day tomorrow I can come back. Your lordship.
No applications because the previous court has fixed dates. We are not disturbing that for the time being. We are taking up applications on Mondays.
No,
Very
2G suit only occupational charge is to be decided and that's it. Thereafter directions for.
I have raised the question of jurisdiction, the court below.
That also has to be decided. at the
No,
time of
definitely that
hearing.
will be decided. But would you like to use affidavit in opposition in the
No,
meeting?
Candy directs in that case.
Can you do it within a week?
Yes, yes.
Then I'll come back with the affidavits.
Yes, I think that will be easier.
Yes, yes.
So, learned counsel for the appellant seeks an adjournment in the matter, full stop. Since the respondent seeks to use an affidavit in opposition, comma, the respondent, one respondent or several?
Not one respondent.
One response.
The respondent is directed to file affidavit.
The respondent.
The respondents are directed to file their affidavit in opposition within a week from date. Full stop. Reply, if any, shall be filed within 3 days thereafter. The application shall be listed for hearing on November 18, 2024 next.
I'm grateful.
Grateful.
Great.
Number 79.
None appears for the parties, adjourned for the day. There is no 3:30 today, Mr. Kormakar?
I have not received any.
What will you do in the hearing matters? We'll dismiss or defer if no day. Yes.
Number 80.
Lordship, I appear for the appellants. Lordship, this is my appeal.
Are they on caveat or?
No, Lordship. This is an appeal against refusal of an ex parte ad interim injunction, Lordship. Lordship,
Refusal?
Refusal, Lordship. My application, my suit for permanent injunction followed by an application under order 3912 for ex parte ad interim injunction.
Why was it refused? Generally not refused.
Lordship, that is a very
Let us
precarious
just see.
situation. Lordship kindly takes up the order from the memorandum of appeal because it's not annexed.
Yes, we are there.
Lordship will see. Lordship, just the factual aspect. It's a 7-storied commercial building, if I may put it, Lordship, in the Bara Bazaar. So different owner, one owner of the building, different shop rooms given to different owners as per sale conveyance deals, not on rent, not on salami, it's on sale.
Right.
I have mine one also annexed. Lordship, what we find out eventually is that the main owner intended to develop the building. Because he sold us most of the properties, I am being one of the owners, there are other owners also, there is a welfare association. There is a minutes drawn up as per the meeting of the welfare association where it is recorded that the owner is trying to now sell off the common areas. Selling of the common area so
Belong
that
to you jointly.
which belongs to us as per the deed, Lordship, those provisions are there. Lordship, the secretary of that owner association had filed a suit. He had obtained an injunction regarding the common area affecting his particular floor. Lordship, so hence we come up.
You are
It's an
wanting
order.
a similar
Lordship, but it's an order 1 rule 8 prayer is there, and I opt for a.
You are
similar
not the association.
I'm not the association. I'm a owner, and I say that let it be in regards to the entire common area, not for the only a particular portion. That has been refused. Lordship will kindly take up the first page of the impugned order. Lordship, that's not numbered. The memorandum of appeal. The first page, the last paragraph. That's where the court below has dealt with it.
All the common areas, that's the ground.
That's the ground.
But without considering order 1 rule 8 prayer.
Lordship.
One. Secondly, that you have a right, joint right, in respect of all the common areas
All
in
the
any
common
area.
areas. That particular portion, Lordship, is a part of my.
What is the injunction you require?
Lordship, the respondent number 1 does not deal or alienate the common areas. Also, Lordship, there is a prayer for repairs. If your Lordship, subject to what your Lordship feels, if your Lordship can appoint a receiver to go and
that will direct you to
stock.
no.
That we can take it up before the court below, Lordship. Also.
No, we'll direct you to serve copy. We cannot dispose of
No,
the
no,
appeal because
Lordship,
we have
no,
not
Lordship. That I can.
We are asking only for ad interim injunction.
Only for that, Lordship. At least he doesn't sell off or alienate.
See your prayers in there.
Lordship, my prayers are in page number 18, Lordship. Prayer A and B would suffice, Lordship.
Sure.
Shiv, I should also just inform you, Lordship, there's a can 2 which was served upon us. It's by one of those secretaries wanting to be an addition of
But they are not here to move
But
it.
Lordship, they would be supporting our case in any manner.
And they're not here
Lordship,
to move
I
it.
just wanted to point it out.
There is no defect in the appeal.
No defect, Lordship. No defect, Lordship.
The appellants have made out a prima facie case inasmuch as the learned trial judge, while refusing ad interim injunction, has overlooked the prayer of the plaintiff stroke appellants under Order 1, Rule 8 of the Code of Civil Procedure in refusing to grant within double inverted blanket, double inverted blanket injunction, also overlooking that the plaintiff stroke appellants have inseverable joint rights over the entire common areas and amenities, thereby apparently entitling the plaintiff stroke appellants to an injunction over the entire common areas. Next para, accordingly but FMA, it was not admitted.
No, Lordship, this is the first time it's coming
Then
up. Lordship, because it's an ex-party refusal, so it was not required to be served, subject to Lordship's convenience. I'll serve it as...
Accordingly, the appeal is deemed to be admitted under Order 41 of the Code of Civil Procedure and shall be heard on the above questions. Next para. The appellants shall serve copies of the application of Can 1 of 2024 on the respondents, indicating that the application shall be listed for hearing along with Can 2 of 2024 on in the monthly list of December 2024. The respondent shall remain restrained by an order of injunction from selling, transferring, alienating, encumbering, and/or creating any third-party interest in respect of the suit property till disposal of the injunction application.
I'm grateful, Lordship. I'm grateful.
হ্যাঁ ডাকতে তো হবে লিস্টে রয়েছে দেখা যাক কেউ যদি রেডি থাকেন শুনতে শুরু করে দেয় অনেকে রেডি থাকতেও পারে পেন্ডিং আছে তো অনেকদিন ধরে Yes.
Lord, my appeal, my lord, appeal from a decree passed in a partition suit. I am seeking accommodation for today. The judgments have to be shown. It's slightly
the
not a long matter. It's a question of construction of a deed.
Ready for hearing? It's otherwise ready.
It was heard, but then
heard in part by who?
No, not heard in part.
Not it was heard,
but
then
partly heard.
after that not taken up.
Lordship, only one.
What has happened? The whole thing boils down the construction of a deed, whether it's a deed of gift or a deed of settlement. My brother has been allowed his share, although he has been excluded in a registered deed of settlement.
Why are we not moving the matter today, Mr.
No, there's some judgments and I'm led by Mr. Basu also in this matter. So kindly accommodate me
Mr.
today.
Basu means?
Saptangshu Basu, I am led by. So kindly accommodate any day.
Lordship, only one thing I would indicate that with a order dated 18/7/2023, they had prayed for an accommodation to file certain documents which were in vernacular language, the translated
The
copies
only deed
thereof.
of gift that is in Bengali.
So
You also have to do that then.
I have to. Actually I did that, but the translation is not very happy.
Happy.
not happy,
So-
but might
so-
be turned out to.
So
happy for
I'll
my concern.
kindly permit me the only document which is relevant for the purpose to have it translated.
So do that within a week, then we'll keep it after Thursday week then.
Very.
Lordship, make a keep a returnable date for the.
Yes, yes, Thursday week will it will appear on November 14th.
My lord, instead of 14th,
17th then,
17th.
next Thursday. Learned counsel for the appellant seeks an adjournment in the matter, full stop. The appellant shall, the matter is accordingly adjourned till November 21, 2024. Full stop. In the meantime, the appellant shall prepare a translated copy of the relevant document as per previous direction of the court and hand over advance copies of the same to the learned advocate on record for the respondent in order for the appeal to be taken up for hearing on the next returnable date.
Deeply.
Read.
In this matter, I beg to appear on behalf of the petitioner. So it's an first appeal, my lord, challenging and decree passed in a suit for specific performance. So both the parties appeared.
Please take the microphone a bit closer.
Both the parties appeared. Pursuant to
You are ready with the appeal? You can start the hearing.
No, problem is there is a defect. Defect is that paper book was filed. There was some defects in the paper book. It was pointed out. So, my lord, in order to cure the defects, we sought for an inspection. But since there is some problem in the file, the department said unless there is a direction from your lordship, they can't give us inspection. So we took up the matter before the registered administration. But
now the entire file is before the court.
Yes, so we can take
yes, will permit you.
And my lord, we can, my lord, kindly adjourn because Mr. Tapos Bhattacharya is leading me. I will request him to take the inspection with me.
এটার রেকর্ডস গুলো আছে এখানে
LCR-টা
একুশ তারিখ হবে 17টা 21 হবে
My lord is keeping it on 21st.
21st sorry the previous one November 21 ই বলেছি
Yes, my lord.
21st we kept it 21st we 17 first I said but then I in the order we recorded 21 yes কালকে না আজকে কালকে
tomorrow I'll do. I'm grateful.
Where will take inspection একটা order record করো learned counsel for the appellant seeks an inspection of the records in order to enable the appellants to properly address the issues involved. Push up. Accordingly, the officers of the court shall give such inspection as and when required by the learned advocates for the appellants.
I'm grateful.
The matter shall be taken up. When should I take up? Thursday week we will keep it. On November 14, 2024.
I'm grateful.
Number 83. My lord, in item number 83, Mr. Shohini Chakraborty is appearing on behalf of the appellant.
Released on the personal ground of one of us within bracket Bhattacharya J with liberty to the parties to seek assignment before an appropriate bench. Seek assignment before a different bench. Your name, please give your name.
Number 84.
84, my lord, Mr. Arup Banerjee is appearing in this matter. He can come not to.
Very well. এটা order record করতে হবে না not today করে দাও।
Order.
We're not recording any order, not today. As we are recording an order. You are for the appellant. You give your name.
Yes.
On the prayer of the appellant, the matter is adjourned for the day. প্রথম দিকের গুলো একটু অর্ডার রেকর্ড করে দিচ্ছি তাহলে পরের বার বেশি দিন ঝোলালে ডিসমিস পরের দিকের গুলো হয়তো প্রিপেয়ার থাকবে না, ঠিক আছে, কিন্তু অন্তত 10-12টা না করে দিলে none appears for the parties adjourned for the day.
Number 86.
Same.
Number 87.
Lord, I beg to appear for the appellant, plaintiff appellant.
Yes.
Lord, understand, Lord, the paper books have already been filed.
If you are ready, we can start the matter, Mr. Conway.
Lord, I'm led by Mr. Ashok Banerjee. Lord, I can start, Lord. Takes it up, Lord, on Wednesday.
Wednesday, we don't take up appeals. Thursdays only. So if you can reach, otherwise, because we are following the whatever is given in the list previously, but we'll add up first. That means the note says that on Monday, application matters will be taken up. We'll put in a first after that. Application matters will be taken up first. So after that, we can take up the other matters. Every day, that will be the norm. So if you exhaust applications, if you exhaust order 41s on designated dates.
Tomorrow, I might be in some difficulty. Lord, takes it up. That's why, Lord,
we'll adjourn for a week then.
Wait.
On the prayer of the appellant, let the matter stand adjourned for a week. And you also have to prepare Mr. Banerjee. That will take a weekend. Yes. Next. Huh?
এটা পেপার বুক আছে না 87 এর পেপার বুক আছে
These are the matters which you mentioned in the morning. Those are being called on.
পেপার বুক আছে
পরে যদি কেউ রেডি না থাকে তাহলে রেকর্ড চাইতে হবে না, যেগুলো বোথ সাইড রেডি আছে ওই সেম অর্ডার রিলিজ করার অর্ডারটা রিলিজড অন পার্সোনাল গ্রাউন্ড অফ ওয়ান অফ আস ব্র্যাকেট এমন নাম with liberty to the parties for
Item number 89.
none appears for the parties adjourned for the day. Okay.
Item number 90.
My lord, item number 90.
রিলিজ অর্ডার অ্যাপিলে আমার প্রচুর রিলিজ হয়, ভাই আছে আছে বাবার যদি করি
Item number 91.
the opposite party number 1 also.
None appears for the appellant. You are ready in the matter. You can start the matter.
No, I'm not ready also.
None appears for the appellant. Push up and adjournment is sought by the respondent as well. Push up accordingly. Let the matter stand adjourned for the day. Give your name, yes.
92 or 91.
Item number 92.
Item number 91.
91.
Item number 91.
91 কি হলো? You asked for adjournment 91. 92. 92 who is appearing?
My lord, we appear for the appellants in this matter. My lord, this has appeared all of a sudden. My lord, a connected appeal is also pending in this case. The
which item?
FMAT 237 of 2017 has been listed today.
Yes.
Another connected appeal, which is FMAT 1290 of 2016. It's a connected matter, same cause of action, same.
No, it is appearing, not appearing in our list.
No, it's not appearing, my lord. If,
on a slip of paper, please write the name so that we can.
I am providing the last order as well as the last mentioning.
Yes, yes, just we need the number of the order.
Yes. So, if my lord can fix it.
Both will appear together next Thursday. Next Thursday means Thursday week.
Okay, my lord.
Learned counsel, you're for the appellant.
Appellant, my lord.
Give your name. Learned, what is your name?
Tande, my lord.
How long are you practicing?
My lord, 2 years.
Mr. Shayan Dev, learned advocate for the appellant, submits that the present appeal ought to be heard along with a connected appeal bearing FMAT numberটা দিয়ে দিও যেটা দিচ্ছেন উনি, comma, since the issues involved are identical and similar. Full stop. Accordingly, let the two appeals be listed together for hearing on November 14, 2024. ওই যেটা দিয়েছেন ওটা দিয়ে দাও ওকে, ওটা ওকে দাও, ও তো নাম্বারটা লিখবে। থ্যাংক ইউ। কল অন দ্য
Oblige, my lord.
93 and 94, your lordship, Mr. Probal Kumar Mukherjee is appearing, your lordship.
For the respondent,
Lordship.
I'm for the appellant.
you start the matter.
Today, my lord, next week, my lord, I'll come back.
Lordship, I pray for 1 week accommodation.
An adjournment is sought by both parties. Let the matter stand adjourned for the adjourned till November 14, 2024. More than 1 week. Give your names, both. Mr. Bhattacharya, whoever is appearing with you also, and he has to give one. No, don't give the name of Mr. Probal Mukherjee. He will be embarrassed. Yes. Next.
Number 96. 95. Yes, in this matter, I am appearing for the respondent. My lord, kindly see the order on 29th August 2023.
What is the order? Have you got a copy?
Order, my lord, the order earlier division made passed by the Honorable Justice Horish Tandon and my the Honorable Justice.
What do you mean to say? Tell us
That
before the file.
records should be brought before this court, but District Judge Alipur Court did not.
Records have not yet come.
No. 2 times. My lord, one, my lord, earlier, my lord, Honorable Justice Tawurboto Chakraborty and Honorable Justice
We'll seek a report then. Let us see
Yes,
the
ma'am.
figures, the file.
Whether this report has come or not, my lord.
Let us wait.
Record, my lord, lower court LCR has not.
Acha.
Long time it is pending, my lord. It is 2017.
Acha, this will it is to be mentioned tomorrow. কালকে তুমি
Yes,
mentioned
yes,
দিয়ে দাও, সব record ফেকর্ড যা আছে সঙ্গে দিয়ে।
Tomorrow.
Tomorrow.
Yes.
Let the matter be listed under the heading to be mentioned tomorrow, comma, since there is some doubt as to whether the previous orders
Yes.
directing the records to be called for has been complied with as yet.
Or not. Leave out.
ইয়ে আদিত্য, কালকে to be mentioned এ থাকবে যা যা যাবতীয় কাগজ।
My lord,
I am appearing for the appellant in this
Release.
matter. I am
Same ground.
I'm ready.
Not on your ground.
my lord.
What is your full name?
Program Dash.
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 Ms. Das, please explain to him later on.
Yes, madam.
Yes.
Item number 97.
Yes.
On behalf of appellant, will kindly take it up next week. My lord, I'll come back.
On the prayer of the appellant, let the matter stand adjourned for the day. তার আগে একটা লাইন অ্যাড করে দাও, non appears for the respondent, তারপর যেটা বলো।
It's a rise.
That's for the respondent.
Item number 98.
97, I'm for the respondent.
No, no, no. The non appears se কেটে দাও। Record his name, Mr. Rai's name also. Give your names. 98, yes.
98, your lordship, the same prayer, your lordship.
Respondent.
The respondent.
None appears for the appellant. On the prayer of the respondent, the matter is adjourned for the day. Adjourned for the day means whenever it comes.
Lordship, kindly fix the matter on 14th, your lordship, the earlier
Not
matter.
too many matters. This will be taken up on day after tomorrow.
Item number 99.
99, my lord, I am appearing for the plaintiff respondent, my lord.
Appearing for the respondent.
2018, my lord.
18.
Yes, my lord. FAT 428 of.
Our determination is from which year? Yes, to 2016 onwards, you have determination. So bad luck on that. We hear the matter.
Yes, ma'am. I want my your lordship here. This one.
Oh, you want it?
Yes, ma'am.
So then bad luck to them.
No, I am mentioning it because but this is a
Long. You are ready in the matter. You can start the matter. You are the respondent. What is the point involved?
One thing, my lords, I'm led by Mr. Ratul Dash. That apart, there's an application which purportedly they have filed for expeditious disposal of this very appeal.
The appeal is appearing for hearing.
Beseeching if this matter be kept any time next week, since my senior is not there.
You're for the appellant.
I'm not for the appellant. I'm the respondent plaintiff in the matter, the suit
Yes,
for
madam,
partition. Respondent plaintiff, he's the defendant appellant. No, respondent
He is the
plaintiff.
respondent. He's the defendant respondent.
No.
Check up.
I'm plaintiff respondent, my lord.
Then
I filed the suit in the Howrah court.
you filed the suit, but still he is the plaintiff.
Against the degree, my lord, preliminary degree, he must pay for the appeal.
Check up. Item 99.
My client is, my lord, Sumita Mitra. On Somnath Day and Shivnath Day, they filed this appeal. They are the brothers and sisters.
You must be in the wrong because he is sitting in the bond.
No. Sumita.
For the appellants, madam.
On the Tanma. On the prayer of the appellant, let the matter stand adjourned for the day. ওনার নামটাও রেকর্ড করে নেবে রেসপন্ডেন্ট।
My lord, fix up a date, my lord. This is my
It will appear next Thursday. It will be in the list next Thursday. Don't expect that all appeals before this will be heard out on the next day. Again, you will get a chance probably. We are recording these orders so that on the second or third occasion, we can take strict steps.
Number 100.
None appears for the parties, adjourn for the day. আর পরেগুলো রেকর্ড করব। None appears, adjourn for the day.
I'm for the appellant being led by Mr. Steve Chakraborty. I'm praying for not today, Your Lordship.
আচ্ছা, not today. আর অর্ডার রেকর্ড করতে হবে। 100টা হয়ে গেছে। Not today. Next.
102.
Lordship, item 102 appearing on behalf of the respondent led by Mr. Sukumar Bhattacharya, only praying for not to.
103 to 105.
Not today.
My lord, 103 to 105, my lord, I am appearing for respondent. Mr. Robindranath Dotto is appearing for the appellant, my lord, for state. My lord, kindly, I am praying for not this week, my lord.
Not this week করে দাও এটা।
Monday, on Monday.
Not this week.
106.
Not today.
107.
My lord, 107 and 8, my lord, I'm praying 1 week time.
7 and 8, not this week.
I'm grateful.
9.
9, Your Lordship, I am for the petition.
Not this week.
Grateful, Lordship.
110.
Not today.
7.
Same.
112 and 13.
Same. Not today.
114.
My lord, 114 to 122, I am appearing for respondent. 22, Mr. Robindranath Dotto is appearing for state. I am praying for not this week.
Not this week. অর্ডার রেকর্ড করতে হবে না। Not this week. এত অর্ডার রেকর্ড করলে সই করতে রাখবে।
123.
Not today.
124.
Lordship kindly makes it not today.
Not today.
125.
Not today.
126.
Same.
127.
Not today.
128.
Same.
129.
Same.
130.
Not today.
131.
Same.
132.
Not today.
133 and 34.
My lord, in both these matters, Mr. Shoini Chakraborty.
Released অর্ডারটা আমার গ্রাউন্ডে।
35.
Not today.
6. 136.
Your Lordship, Mr. Shinjoy Das is appearing on behalf of the petitioner. He's left for some reason.
Not today.
137.
Same. Not today.
138.
Not today.
139.
39, my lord, appearing for the petitioner, my lord, but your lordship, my lord, earlier, my lord, appeared
I appeared in the matter.
for the petitioner, my lord.
Release on personal ground of one of us, আমার নাম।
39.
Mr. Dev, please give your name.
140.
Not today.
141.
Not today.
142.
Not today.
143.
Released
My lord,
personal ground
please.
one of us. Thin.
Grateful.
144,
Not today.
45,
Not today.
146,
I'm praying for not to.
Not today.
147,
Same.
148,
Ready?
Praying for time.
Not today.
149,
Same. Not today.
150,
Not today. না জাস্টিস ভরদ্বাজের লিস্টে আবার কল করো পরে কথা পরে চলে যাও জাস্টিস ভরদ্বাজের লিস্টে